Also, just to let you know, we have in April, there will be on the 21st of April, there will be working in HR and the civil service, which you can sign up on the branch website. And then again on the 28th of April, we hope to host an event on paying it forward with Thorpe Molloy, which is about social responsibility. We're still waiting on some details on that event, but once those are finalized, the event will be added onto the Eventbrite and onto the branch website. The bidding committee will be looking for a secretary and branch treasurer. So if you'd like to be considered or want to volunteer for doing that, we'll add it's the North Scotland email address that you email. We'll add it to the chat if you're interested in that. If you just email them, and someone will get back to you with some further details. Our Highland Island Inverness branch is also looking for some more committee members. If you're interested in joining our committee, the sub branch committee, again, just email the North branch and we'll get back to you with that. At the end of the session, there will be an opportunity to give us a survey will be sent out by your email for an opportunity to give us some feedback. If you could please do that, it really helps us with collating the information and making sure that we're getting you the right events and that the process is smooth and easy for you. Right, so those are updates for our event today. We're really pleased to welcome Jill Shaw, who's kindly offered to take some time out of her already busy schedule to give us an employment law update. Jill is a practicing employment and discrimination lawyer and part-time lecturer at Inverness College, where she is program leader for the college CIPD professional qualifications. So I'll hand over to you now, Jill.
Thanks very much, Carolina, and good evening, everybody. It's great to be along back at the CIPD, albeit not in person, but thankfully we have the technology in place where we can still catch up. So thank you to the North Highlands and Islands group for the invitation to come along and have a chat to you. So tonight my plan is to have a look at some of the recent legislative and case law updates so far as they relate to employment law. And we only have an hour, so it's going to be a bit of a whistle-stop tour. I've agreed with Shona that I am going to use a few slides tonight, and I am going to send those on to her, so don't feel that you have to take copious notes from the slides. She's going to circulate those after the event, so the slides will be available, and I will pop some links in the slides as well about some of the things that I've been talking about. Those of you who know me know that I like to chat, but I like sessions to be quite interactive too, so more than happy to take questions as we go along. And I understand that you'll be able to unmute yourselves, so if you want to just jump in with a question, feel free to do that. If you want to pop your question into the chat, then I'll try and keep an eye on that, and Shona has agreed to highlight for me any questions in the chat that I miss. So if you want to do that, or just stick an asterisk in the chat so that we know that you want to ask a question, then we can take a pause for that to happen. So any thoughts or comments or questions that you have along the way, please just feel free to jump in with those. So I'm going to share my screen now, and we did a little test of this and it worked, so hopefully it will work again. Can you see the slides okay? Yeah, we've got some notes there, great. So in terms of what I plan to cover, and yeah, we'll see where we get to in terms of the time, but I wanted to have a look at some recent changes in employment status. You no doubt will have noticed those in the media. They've been pretty heavily reported, so I probably won't spend too long talking about that. Look at some recent discrimination developments, and quite significant developments in discrimination case law, plus a helpful reminder, so we'll touch on those cases. Then look at working time. There was quite a significant case recently on working time, particularly, I think, for those of you who are in the care sector, probably some sighs of relief on the back of that judgment. So we'll look at that. I found one case about COVID. I mean, obviously, I think we are all reacting to the pandemic and the impact that that has on our organisations. but there's quite limited case law at the moment. We're going to just have to wait for those to trickle through the tribunal. But there was one about the use of PPE and face masks, so we'll have a look at that case. And then just some final bits and pieces, kind of smaller changes, but changes that may potentially have some impact on your business or your organisation. So kicking off then, looking at employment status, I imagine that most of you have seen some of the commentary about the Uber decision. Yes, few nods. Yes, so obviously the Uber case was about employment status, which has become a bit of a hot topic. These cases have been trundling through the courts for some time, and this was the case landing in the Supreme Court, which, so far as the UK is concerned, is the highest civil court. So it's made its way in terms of levels of appeal right the way to the top, looking at employment status, which is particularly prevalent in what we have now, quite a common gig economy, and really questioning what the distinction is between those who are self-employed and those who are workers. So here, when it got to the Supreme Court, what the court said was, here the Uber drivers who brought the claim were workers. And what the court did was look at the reality of the working relationship in Uber. And although there was some freedom for drivers to choose when they chose to work, when they were working, there was a sufficient degree of control by Uber while drivers were working for the court to be satisfied that they were workers rather than self-employed. And obviously that has implications in terms of entitlements, benefits like paid holiday, like rest breaks, like entitlement to the national minimum wage. So for those who have individuals in place on a gig economy type basis, really significant decision. Not great news for Uber, although I think there is a recognition that over the time that these cases have been going through the courts, the contractual arrangements have changed somewhat. But I think for anybody who has an organisation where you have independent contractors, so you have that type of arrangement in place, you've really got to look at what is happening in practice rather than just what is written into the contractual provisions. And I think Uber is a big warning for employers about that. Any thoughts or questions on that? I have lost the chat box. I'm going to see if I can bring it back up.
There doesn't seem to be any questions just now in the chat box.
Perfect. Yeah. If you can just keep me up to date with that, Carolina, yes, that would be really great. Yeah, I seem to have lost my chat box for some reason. So yeah, thank you. Okay. So the next thing I wanted to touch on was discrimination, and a couple of quite significant discrimination cases. So Taylor against Jaguar Land Rover was one of those. So that came out just towards the tail end of last year. I think it was in November. And is anybody familiar with the Taylor and Jaguar case? Have you heard about that? No? A few shakes of the head. It was a claim for discrimination, a claim for harassment, and it was based on a protected characteristic of gender reassignment. And I read the judgment in this case, and it is pretty rare for me to read a judgment and cry. But I cried when I read the judgment because the campaign of harassment in this case was just awful. It was horrific to read what this individual, Taylor, had been subjected to in the workplace. Really awful campaign of harassment. And the question in this case was, if you have an individual who is not necessarily undergoing or intending to undergo medical treatment as part of a gender transition, gender reassignment, are they still caught by the definition of gender reassignment? Do they still enjoy the protection of the protected characteristic of gender reassignment for the purposes of the Equality Act? So this case was the first time that the courts have had to look at the question of whether the protected characteristic of gender reassignment will extend to gender non-binary staff who are not necessarily intending to undergo medical treatment or who are currently undergoing medical treatment. And what the court said was that yes, it does. So quite a significant shift in terms of what we now know about the extent to which the characteristic of gender reassignment will apply. So, as I say, Taylor against Jaguar Land Rover, the first time that the courts have looked at that case, and they've said, yes, gender non-binary staff do enjoy protection. So in terms of what that means for employers, obviously there might be a need to go back and look at your equalities policy. If you provide equalities training to your staff, then you might have to go back and look at that to make sure that that is up to date, so that you make sure that you are flagging for staff so far as discrimination is concerned. Any thoughts or questions on that?
We had some questions popped up. So one on the Uber was how has Uber changed the contract to avoid this situation? There was one question.
Yep, I think there have been a number of changes contractually to the terms and conditions that drivers are engaged on as the cases have kind of moved along. So I think the court was looking at the claims as they were raised at the time. So I'm not sure that Uber have deliberately changed the contracts to avoid the situation, because the claim was raised by the claimant at the time, and that's what the court will have to look at. But I think the point has been made in the commentary that the terms and conditions that contractors now are engaged on are quite different. Sorry, I think Ashwini, I think your mic is on. We're getting a little bit of background noise from you, Ashwini.
Here we go.
Perfect. So yeah, I think there were a number of changes, and if you want to delve into that, then I can pass on further information. But there were a number of changes to the contracts because it's taken so long for the different levels of appeal to make their way through the various stages of court action. Yeah. But I think going back to what we said about employment status, one of the things that is really important is to make sure that what is in the contract reflects what is actually happening on the ground. So I think, although the Uber contracts characterised individuals as self-employed contractors, I think because of the amount of control that Uber still had over those individuals who were engaged on that basis, that's why the claims were successful. That's why Uber lost the appeal. So I think the more, if you are characterising somebody as self-employed, then you've got to make sure when they're working, when they can take holidays, you're not subjecting them to your disciplinary policies and procedures. So the less control as an employer that you have over an individual who is self-employed, the better. Because control is one of the key things that a tribunal will look at when they decide, is somebody, notwithstanding the label that you put on the engagement, is somebody actually a self-employed contractor, or are they a worker or indeed an employee?
Thank you. And then for the Taylor versus Jaguar Land Rover case, Alison's asked, what was the award in this case?
I can't remember off the top of my head, but in the slides, I will put a link to the judgment. But it was significant, I think tens of thousands of pounds.
So it looks like some are having some problems with sound. If anyone else is, if they could just leave a message and we'll see if we're looking into it. Mine seems to be okay at the moment. And then there's a question from Lindsay, I think to do with the Uber case again. Am I correct in thinking that the drivers are still taxed as if they are self-employed?
Yeah, and I think, well, that's a good question, and I think there are complications with self-employed relationships and IR35, because you can have an individual who, for tax purposes, under the IR35 tax rules, is an employee or is self-employed, but you can have a different conclusion in an employment law context, which creates anomalies, which is not helpful. And one of the recent rules for public sector organisations and medium and large sized private sector organisations now from the 6th of April, those organisations now have an obligation to characterise the employment relationship for IR35 purposes, what it is that they believe that employment relationship to be. So that is another new development. But I think the fact that under employment law you can have a different status than under the IR35 tax rules is not particularly helpful, but it's what we have.
Thank you. That seems to be all the questions in there, and hopefully the sound issue resolves itself.
Okay. Just one note on gender reassignment and those in the trans community and those who identify as non-binary. I was in touch with a client this week, and the client sent me an email. And in their email, they had something that I hadn't seen before. And they had put in their email footer kind of brackets with their pronouns, she, her. And then under that, a link saying, I have my pronouns in my email signature and this is why it's important. And when you clicked on that, it took you to a link by an organisation in the States who are encouraging those of us who are cisgender, so kind of born into the right gender, so female but believe that you're female, or male and believe yourself to be male. So those of us who are cisgender can easily disclose our pronouns, she, her, he, him, whatever. And it makes it easier for those who might not use pronouns, she, her, who might use they, them, or other pronouns, to then disclose their pronouns. So it's about, I guess, creating a kind of safe space for people to feel encouraged to do that. And having seen that in that email, I called her up and I said, do you know what, I've never seen that before. I'm really impressed by that, and I'm going to adopt that too. And she told me that she was doing it just because they have a member of staff who's transitioning, and they wanted to be supportive and create that kind of inclusive workplace. And I thought that is a really great practice to adopt for employers and workplaces. So it's something that I've done. And when I circulate the slides, I'll put the link into the article. So I updated my email signature this week, and also my LinkedIn profile, to put my pronouns on there, which for me are she, her. And one of the things that the article talked about was that there had been a university which was in the States, and one of their students had been looking for a work placement, and that student identified as non-binary. And they were looking for a work placement and had gone onto LinkedIn to kind of check out some of the companies that they were considering going to work at. And when they saw that the managing director of one of the companies that they were checking out had put their pronouns in their LinkedIn profile, they had reported back to their tutors that actually that made them think that is the kind of company that I can go have a placement with and feel like it is a safe place for me to be. And the feedback to that organisation and to that university was that, for the student, that was really quite significant. So I'm flagging it just because it's something that came to my attention this week, something that I was really impressed by, and a really simple, straightforward practice that lots of us could adopt, but make our workplaces more inclusive. Yeah, I'd be interested, does anybody already use their pronouns in their email signature?
There's a comment here from Laurie, says the Royal Mail encourage all staff to put their pronouns in an email signatures. It's really inclusive move.
Yeah, absolutely. Great.
There was also a comment here from Douglas. The Taylor Award was 180k.
Thanks, Douglas. I can always count on you to find the facts. Yeah, no, it was fairly significant, but it was an absolutely horrific pattern campaign of harassment in that case. Really, really awful.
There's other recommendations about getting a diversity organisation into review practices and getting a diversity champion and things like that as well. Yeah, so it's quite far-reaching.
Absolutely, yeah. I think that organisation, I guess it's an example of how to get it wrong, really badly wrong. because I think that, there was a real culture of harassment there, and an individual who was screaming for support and none was available. So yeah, I think if you want to read a judgment about how not to do it, this is definitely the judgment to go and have a look at. So that was Taylor against Jaguar. Another kind of fairly significant discrimination case, which I think acts as a kind of helpful reminder for us, was the Ali case, which again was just, I think it was February this year, so fairly recent. And it relates to the type of situations where you have a discrimination claim, and because of the nature of discrimination claims, they can be raised against the employer, but also against any individual who carries out an act of harassment. So that might be an HR manager or a line manager or even a colleague who's harassment. So discrimination claims are not always just raised against employers. They can be raised against other individuals within the organisation too. And where that happens, an employer will have two choices. They will either stand by their staff, and usually when that happens, the employer agrees to accept liability and releases the individuals from the claim, so they are no longer respondents to the claim. Or the other approach is the employer kind of cuts loose the people who are the individuals who have carried out the harassment, and they rely on what's called the reasonable steps defence. And in doing that, the employer is basically saying to the tribunal, we have taken all reasonable steps to make sure that discrimination doesn't happen in our workplaces. So these individuals have gone off on a flyer and we are not responsible for that. So where an employer wants to use that reasonable steps defence, normally they will point to things like, they've got an equal opportunities policy in place. They have, perhaps an equalities bullying and harassment procedure to deal with things that happen. They provide equalities training regularly to make sure that staff know what is and is not acceptable. So those are the kinds of things that employers would do and would point to if they were trying to show that they'd taken all reasonable steps, and kind of get themselves off the hook for any liability if individuals within the workplace have carried out acts of discrimination. And in this case, that's what the employer tried to do. So they pointed to the fact that they had an equal opportunities policy and that they had equalities training in place, but the court here said the training that they had provided was stale, it needed updated, it needed refreshing, and on that basis, that was insufficient for the employer to make out their defence. So I guess in terms of the implications, if you are going to want to put yourself in the strongest position to be able to rely on that defence, if you have particular individual employees who go off on a bit of a flyer and do things that you've told them and made clear they shouldn't do, then you've got to make sure that your policy and procedure are up to date, obviously, but also any training that you have is up to date and is effective. So I think that is a helpful reminder to make sure that you keep those things up to date and fresh, particularly when things are changing all the time, as we see from the Taylor and Jaguar case. Okay. Any thoughts or questions on that, or on discrimination in general before we move on? Anything in the chat, Carolina?
No, so we just have a comment from Pauline. The first person I saw using her pronouns was Melody, which totally makes sense.
Yeah, perfect. Okay, so working time then, and I said, yeah, probably a big sigh of relief for those in the care sector. We got the Supreme Court decision in the Royal Mindcap Society against Thomas and Blake case, which was a test case, and it involved the national minimum wage and sleep-in shifts. So the situation where you have individuals who sleep in, either with a particular individual or in a care home, for example, and whether or not time that you are sleeping in with an employer amounts to working time. Because if it's working time, then you would be entitled to receive the national minimum wage for all of the time that you are in the premises, even though you're able to sleep. So that's the question that the court was looking at, and Supreme Court case, so it's kind of gone through all the levels of appeal right up to the top. And what the Supreme Court said was that if it's sleep-in time, it doesn't qualifies as work. It's not work. So if you're able to sleep, and if you only have to respond to emergencies, then the employer is not liable to pay the national minimum wage for all of the time that somebody is sleeping in. You would only be entitled to be paid for the time that you're actually working. So if you do have to respond to an emergency, for example, then obviously that would be working time, because it's time that you're required to carry out work. But even if you're on a sleep in, if you're able to sleep and you're only responding to emergencies, all of that time is not working time. So all of that time does not attract the national minimum wage. So yeah, big sigh of relief for lots of folks in the care sector who otherwise would have been facing, I think, fairly significant back payments. And I think, as I've seen it, the way that it operates most in the clients that I've worked with is that if you do have somebody on a sleep-in shift or an on-call shift, they tend to be paid an allowance plus payment for whatever they have to do by way of actual work if there is an emergency that they have to respond to. So that practice is still okay on the back of this judgment. So any folks in the care sector on the call? I know there's at least one, so yeah, big sigh of relief for those individuals. Yeah, Caroline, I think you're on mute. I don't know if
sorry. Yes, sorry. Laura Dobson just said, yep, that's her. She's one of them.
Great. So yeah, good news for employers in that, just maybe not so good news for employees, right enough, who are on sleep-ins, but certainly good news for employers. And I think most of the folks on the call are probably here on behalf of their organisations. So yeah, we can land on the side of the employers this evening. Great. Okay, so COVID then was the next thing that I wanted to talk about. And as I said, there are not many COVID cases coming through the tribunals, partly because there was such a big shutdown and there was such a big backlog. So, anybody who is involved in organisations where, I guess touch wood, where you do have employment claims arising now and again, you will know that the contentious stuff pretty much fell off a cliff in lockdown, and there's been very little movement, although I guess there are some remote hearings, not that many in my experience, and things are moving quite slowly. So, I used to say to clients, you can expect to get a tribunal hearing in about 6 to 8 months. Now I'm saying it's going to be about a year and a half, just because of the backlog and the fact that things are moving fairly slowly. So very few COVID cases, partly because of lockdown, partly because it just generally takes some time for cases to get to the tribunals anyway. But I did come across one case, and it is just an employment tribunal level judgment, so just the first level. And those of you who know anything about how case law works and the system of judicial precedent, is that where you have an appeal to a higher court, that decision then becomes binding on all of the lower courts. So, for example, if you have a decision at an employment appeal tribunal, then all of the employment tribunals underneath that have to follow that. If we get a decision by the Supreme Court, then all of the courts have to follow that. That's as high as you can go. So basically the way that the system of judicial precedent works is that when you have a higher level court, everybody has to follow that. So this is not an appeal decision, so not binding on other tribunals who would just be considering that at the same level. But I guess the other point is that it only goes so far, so we'll look at that in terms of the implications, but it's the only one that I could find that was about COVID-related PPE, which is a question that I get asked a lot. Can we force people to wear masks, and can we force people to do this, and can we force them to get the vaccination, which I think is going to be the next big issue for employers to be grappling with. But in this case, the Kent Foods case, the Kent Foods worked with a particular supplier, Tate & Lyle, the sugar producers, and Tate & Lyle had a requirement for people on their site to wear face masks. And the claimant didn't wear one on the Tate & Lyle site, and obviously Tate & Lyle pulled him up about that because that was part of their rules. They didn't have a written rule because it was just a temporary measure during the pandemic. But when the driver was pulled up, he said, well, I'm not breaching government guidelines, I'm just in the cab of my lorry, so I'm not going to do it. And he tried to get Tate & Lyle to change their rule rather than comply with it. So his employer, Kent Foods, who were working with their supplier, Tate & Lyle, were a bit upset by that. And I think it had been pointed out to him that, you know, even if he was in the cab of his lorry, if he's having a conversation with somebody outside the lorry, you know, there still could be droplets of saliva falling on them, which when you think about it, is a bit disgusting. But, you know, that was part of what was put to him. But he still refused to wear the mask. His employer, Kent Foods, then pulled him into disciplinary hearing, where he showed no remorse, insisted that he wasn't in breach of the government guidelines, he wasn't doing anything wrong. The supplier had been in touch with Kent Foods to say, if he's not going to wear a mask, we don't want him to be on site. And 90% of the work that Kent Foods did involved that particular supplier. So all of the driving from, you know, their premises to Tate & Lyle, 90% of the work from their site involved Tate & Lyle. And so on the basis that they refused to have him on site, there was no other work for him to do. And the fact that he had breached their trust and confidence because he refused to accept that there was an issue, and because he'd kind of almost threatened their relationship with their supplier by, you know, not just saying, okay, I'll put my mask on, but saying, well, you have to change a rule and I'm not breaching the government guidelines. They dismissed him. And when it came to court, albeit just at the employment tribunal level, his unfair dismissal claim was dismissed. So the court said that dismissal in this case was within the band of reasonable responses. So it was within the band of reasonable responses for Kent Foods to bring his employment to an end. So I think in terms of where that takes us, I think it's welcome for employers. You know, if you are insisting that people wear face masks, then on the face of it, you might say this is a good result. However, I think it's important to bear in mind that although the unfair dismissal claim was kicked out, here the dismissal was not because he had refused to wear a face mask. It was because of his kind of attitude, his lack of remorse, and the potential damage to the relationship with the supplier by refusing to comply with their rules and trying to encourage them to change the rules rather than just wearing the mask. And also, the employer argued that because the supplier had said we don't want him on site and there was no other work for him to do, that was a dismissal for some other substantial reason. So as we know, there are 5 potentially fair reasons. You know, we've got misconduct, we've got capability, which would be kind of poor performance, or, you know, ill health, absence. We've got statutory breach, so like breach of immigration rules or whatever, if you continue to employ somebody. We've got redundancy, and we've got the kind of catch-all, which is some other substantial reason. And here, part of the employer's argument was, we've lost trust and confidence in this individual, so therefore dismissal is within the band of reasonable responses. And for some other substantial reason, i.e. the supplier for whom we do 90% of our work is refusing to have him on site, therefore we can't continue to employ him. So I think because of those particular facts and circumstances, this is not really a case about, is it reasonable to insist that somebody wears a face mask? I think there are lots of things going on in the background here. And I think, unfortunately, we'll just have to wait and see how the courts deal with some of those issues, because ultimately it will be for the courts to decide what is reasonable. And I think you've got to imagine that it will to some extent be a degree of risk. So, you know, again, if you work in the care sector, for example, where you're dealing with vulnerable people, then it is probably easier to demonstrate that dismissal for refusal to wear a face mask is within the band of reasonable responses than it would be if it's somebody who's no contact with the public, who is you know, working in a place where they are socially distanced from colleagues. So I think it will come down to the particular facts and circumstances of each case. But I guess as the first ever case, as I understand it, about PPE, which is COVID related, this seems to be going the employer's way, albeit with a lot of stuff happening in the background. Any thoughts or questions?
We had one question from Douglas, but he answered his own question.
He answered his own question.
He asked what was the reason for dismissal, and I think he noticed it was some other substantial reason. And then there was a comment from Catherine to say that she also works in the care sector, but nothing so far other than that.
All right. Okay. So just a few bits and pieces then to kind of wind us up, and then I've got a couple of things that are on the horizon. So for those who may not have noticed, early conciliation through ACAS, which is now compulsory. So anytime now that an employee wants to go to tribunal to raise a claim, there is a mandatory process of ACAS early conciliation. So what happens there is that before raising an employment tribunal claim, the individual has to go to ACAS, has to kick off the process of early conciliation. So ACAS, once they get the contact from the individual employee, would then contact the employer to say, do you want to engage in early conciliation or do you not want to engage? There's no obligation on the employer to do that. So if the employer says no, not interested, then ACAS will just issue their early conciliation certificate and the individual is free to raise their claim. If the employer does want to engage, then ACAS then will kind of act as a go-between to see if they can broker any kind of settlement deal in advance of a claim being raised as a way to resolve the issue. And it used to be the case that the early conciliation period lasted for 4 weeks. And the effect of that was that it effectively kind of stopped the clock in terms of the qualifying time limit for raising your tribunal claim, which is 3 months less a day. But the ACAS provisions would stop it effectively for a month or so, although it's a little bit more complicated than that. And if at the end of the 4-week period, the parties were close to settlement, ACAS had a discretion to extend the period of early conciliation by up to 2 weeks. And if there was still no resolution, then they would just issue the certificate and the individual was free to go ahead and raise the claim. Otherwise, you get a settlement agreement through ACAS on a COT 3, and that would bring the matter to an end. From the 1st of December last year, what was previously the kind of 4-week period with a possible 2-week extension has now become a standard early conciliation period of 6 weeks. So you now have 6 weeks for early conciliation as a precursor to any employment tribunal claim. So that is a bit of a change. So I guess it extends the period of early conciliation unilaterally across the board, regardless of how close you are to settlement come week 4. So little technical change there. Also, the Information Commissioner's Office at the tail end of last year published new guidance. So the Information Commissioner is the individual in the UK who deals with data protection issues. And the ICO, the Information Commissioner's Office, they operate for data protection throughout the whole of the UK. Where you're dealing with freedom of information, there is a split. So we have our own kind of separate Scottish Information Commissioner for freedom of information issues. So that will apply to those working in the public sector, where you might receive freedom of information requests. But data protection throughout the whole of the UK is dealt with by the Information Commissioner's Office. And one of the issues that often arises for employers, particularly if there's been a falling out with employees, or there is a potential falling out in the offing, often you will receive a subject access request from employees asking for copies of all of the information that you hold about them. So, copies of their personnel file and things like that. And in November last year, the Information Commissioner's Office issued updated guidance for employers about how to deal with subject access requests around data protection. So I will pop the link. I tried to put it in the slides, but it was giving me just an abbreviated thing that just said ICO, so I figured that was not going to be that helpful for you. But I will put the link into the slides so that when I circulate those, or when Shona does that on my behalf, then you can click through to that. So that's quite helpful guidance. And if folks haven't used the ICO website before, it's one that I recommend all the time, like to my students and to my clients. It's really accessible. Any questions you've got about data protection issues, they've really detailed guidance for employers, generally about data protection in the workplace. So if you haven't been on the ICO website before, it's one that I would really encourage you to check out if you've got any issues around about data protection. It's a really helpful one. But of note recently has been their new guidance about how to deal with subject to access requests. You still clear on questions, Carolina?
So we had one from Shirley Ann. She said, regarding the early conciliation, if the employee hasn't made contact with, and can we query that, i.e. contact the ACAS and ask why no contact, or did they have contact? And then she's got a comment after that, if it has gone straight to tribunal claim.
Usually you wouldn't, as an individual, you won't be able to raise your tribunal claim if you haven't gone to ACAS early conciliation, because when you raise your claim, there is a box on the claim form for you to put in your ACAS early conciliation certificate number. So you have to have done that to get the early conciliation certificate number to put into your claim form. And that happens either when you contact ACAS, they get in touch with the employer, and the employer says, we don't want to engage in early conciliation, at which point ACAS issue their certificate. The individual will get the certificate number and they'll then be able to insert that into their claim form. Or if you have a negotiation back and forth through ACAS, but you're not able to reach a resolution, and one of the parties said, I don't want to engage in this process anymore, so now that would be within that 6-week period, then they would just instruct ACAS to issue the early conciliation certificate, so it might happen then. Or if you get to the end of the 6 weeks and there's no agreement, then ACAS will just issue that early conciliation certificate automatically. So the tribunal will not accept a claim form now if it doesn't have an early conciliation certificate number in it. It will get bounced and the claimant won't be able to proceed with the claim. And if they make one up, then as the employer, because when the claim is then submitted to the tribunal send the claim form on to the employer, and the employer then have 28 days to respond and lodge their ET3. So if in the ET1 the claimant has put in an ACAS early conciliation certificate which is not accurate and made up, then there is a box in the ET3 that the employer would then respond to saying, I think it says something like, is the information about early conciliation correct? You would just tick no, and then probably there would then be a preliminary hearing to discuss whether or not ACAS early conciliation actually had taken place. And in that case, the tribunal is likely to ask the claimant to produce the ACAS early conciliation certificate, which they would be unable to do. Because I think there was one situation that I was aware of where I think it was a dud email address or something had been given for the employer, or it was a non-active email address or one that nobody was picking up. So early conciliation had commenced, ACAS had emailed the employer at this dud email address. There was no response, and then they issued the early conciliation certificate to that same email address. So from the claimant's perspective, it looked like early conciliation had happened, but actually that hadn't happened. From the employer's perspective, they hadn't been notified properly. But general rule is, if you haven't gone through early conciliation, the tribunal will bind your claim.
Thank you. That's great.
No worries. Any other questions, Carolina?
No, there's not. That was the last question on there.
Perfect. Okay, so on with our bits and pieces. Just again, another kind of technical one. From the 1st of April, there's been a slight change in terms of the legislation around the national minimum wage. The retention period now has doubled. So it used to be that you were required to keep information around about national minimum wage for 3 years. It's now 6 years. So that may involve an update to any retention policies that you have in terms of the length of time for data protection that you hold onto records. So again, just slight technical tweak to the legislation, but obviously an important one in terms of your obligation to keep those records. So now 6 years instead of 3 years. And again, another kind of technical shift. So this is in relation to the vento bans. So vento is the case that we look at when we are deciding how to quantify the value of a discrimination claim. So I guess put bluntly, discrimination claims are valued depending on how upset the individual is. So the more upset somebody is, the more valuable their claim is. So if there is a more significant psychological impact in terms of their injury to feelings, then that claim is going to be more valuable. So Vento is the case where the courts first laid out what they call the lower, the middle and the upper bands of discrimination. So depending on the seriousness of the discrimination and the impact on the individual, we categorise the value of the claim on the Vento bands. And every now and then there is an update, for inflation and the value of money. So the Vento bands are updated, and we had another update on the 6th of April. So now, where previously I think it was £600 to £6,000, if you have a claim which is less serious, it's in the lower band, it's valued between 900 and up to 9,100. So that might be a one-off incident or something fairly low level in terms of harassment that the individual is a little bit upset about, but not too upset about, doesn't have any lasting impact. That would fall into the lower band. So you're looking at claims of up to, or a value of it for injury to feelings of up to about £9,100. In the middle band, from that up to about 27.5-ish. And then in the upper band from 27.5 up to about 45.5. And then anything which is exceptional will then fall into, plus 45,600. And I've only seen one of those in my time, and it was a pretty horrendous case too. But I guess that gives you some context for the kind of figures that Douglas was talking about in the Taylor and Jaguar case, where you're looking at an award of £180,000. And I'm not sure how much of that was loss of earnings either. I don't know if there's any breakdown, Douglas, but yeah, normally the kind of more serious, and that's where somebody suffered some real psychological damage. They may have been forced to go on medication, they might be unable to work for a while. Those are the upper band cases where things are more serious. So a slight tweak to the Vento bands, an increase in those, and new levels of injury to feelings awards depending on the seriousness of the injury. Any questions, Carolina?
Yep, so we've got a question from Victoria. She says, regarding the discrimination claim being made against the individual rather than an employer, at what stage does the employer cut loose from the individual?
It depends. I think if the employer is going to cut their staff loose, then usually they make that decision fairly early on in proceedings, because it's just easier from the tribunal's perspective. And normally when the claim is raised and when the response goes in a discrimination claim in particular, there normally is a preliminary hearing. And normally in advance of that preliminary hearing, there is a case management agenda issued to each party. And what happens at the preliminary hearing is you have either the parties or the representatives go on a call with an employment judge to talk about, what exactly is the statutory basis of the claim, what witnesses are we going to need, if it's a disability claim, do we need medical evidence, who's going to provide that, who's going to pay for that, who's going to be responsible for producing the joint bundle of documents, how many days do we think we're going to need for the tribunal, so are we going to explore judicial mediation as an alternative. So I think one of the things that would be discussed at the preliminary hearing, where you've got a number of different individuals, is the approach that the employer is going to take, and whether they are going to accept liability, in which case the other parties can be excused, or whether they are going to argue that they've taken all reasonable steps. Because by the time that the preliminary hearing has been fixed, the employer will already have submitted their response. And if they are going to rely on that reasonable steps defence, they will have to have pled that in their ET3, so that will have to be part of their response. So they will have to say, we're relying on the reasonable steps defence, and here are all the things that we've done that mean that we're not liable. So they have to do that at the time of submitting the response, and then they would have to then discuss that at the preliminary hearing. Because if you've got 3 respondents, then that is a significantly longer hearing than if you just got 1 respondent, because each of those individuals would have their own legal representation, or they would be representing themselves. So each witness would have to be cross-examined by 3 lawyers rather than just 1 lawyer. So it extends the process. So there would have to be some discussion about that at the preliminary hearing. But if there was going to be an attempt to rely on the reasonable steps defence, that would have to be in the ETC. So that is usually a decision that the employer makes pretty early on. And usually, in my experience, the employer, well, if they think they're in a position to successfully argue the reasonable steps defence, they normally know from having done their initial investigation to gather the information that they need to respond to the claim, whether or not the individuals have done something just as a complete flyer, or if it's been something in the course of their employment which, you know, they don't consider is discrimination, or they're going to argue that it's not discrimination. Does that answer your question? Yeah, I think the short answer is pretty early on. Yeah.
So Victoria says yes, thank you. There was also a comment from Douglas, I'm not sure what's in relation to. He says, didn't see a breakdown. And then...
Okay, that's where, yeah, that was, I think, in relation to the Taylor Jaguar case where I said, was any of the £180,000 about loss of earnings, or was it just all about injury to feeling?
There's a five or six different kind of actions that were agreed. It seemed to be by consent, including the value of the award. So I guess it was almost, instead of breaking it down, that's something
on a global figure, yeah, and that would make sense if it was exactly 180,000, because if there was a breakdown for loss of earnings or whatever, you would normally have the kind of 0.32 pence or something on the end of it. But it sounds like there's been, and sometimes that happens, you know, because sometimes the other thing that can happen in a claim is you have a hearing on liability, and you have remedy separate, so that if liability is established, then you come back on a different day to argue about how much compensation is going to be awarded. So it sounds like what might have happened here, if it's by consent, is liability has been established, the parties have then gone away and agreed themselves what actions the employer is going to take and how much compensation is going to be given, to avoid the need for a remedies hearing.
Yeah, and they've also been ordered to pay 25% of the claimant's costs. I don't know if they've got a figure for that.
Which again is really unusual. I think I've only seen costs awarded twice in the 20 odd years that I've been doing this. It's really rare for a tribunal to make any cost, any award for costs. Generally, you can expect that whatever you pay in legal fees, you're not going to see back. So I think that just emphasises how bad the treatment of this particular individual was, the fact that they've recovered even part of their costs. For me, the only twice that I've seen it happen, one was when my client went to court, and actually it also was in a gender reassignment harassment complaint raised by one of their staff. So there was a complaint for gender, so sex discrimination, sexual orientation discrimination, and gender reassignment discrimination, all harassment complaints. And those complaints were made against 13 of my client's staff, and they were a fairly small organisation. They only had about 50 staff. So we had a 4-day tribunal lined up, and I had 13 witnesses waiting in the wings. And that had a significant disruption in terms of my client's operational delivery, because they only had 50 staff. So having 13 people, you know, lined up to give evidence in the tribunal, that was quite an impact. Some of the staff were just 17 and 18 and had to kind of be prepared to come on to tribunal with their parents because they were a bit traumatized. All of the allegations of harassment were denied. We got to the tribunal on a Monday morning, and the claimant didn't show up and didn't offer any explanation for not being there. And it turned out, and I don't actually know how this is possible, but it turned out that her lawyer had not been in touch with her for 6 months, because we'd had a previous hearing that had to be discharged because she was ill. So we kind of rescheduled it for 6 months later. And her lawyer had written to her to intimate that the hearing was going to take place. But yeah, she didn't show up. She didn't give any reason why she wasn't there, and her lawyer hadn't been in touch other than writing to her to say be at the tribunal on this day. Now, how you prepare for a hearing without speaking to your client, I don't know, so I'm not going to tell you who that lawyer was. But yeah, not a lawyer that I would want to engage. But anyway, on the basis that she wasn't there, I asked for the claim to be dismissed and asked for costs. And I think we got 20% of our costs, which was not significant. And that was in a case where, you know, we had quite significant disruption, 13 witnesses involved, serious allegations, and the claimant just didn't show up. So it's pretty rare for costs to be awarded. So yeah, I think that just underlines how serious the discrimination was in this case. Yeah. Anything else, Carolina?
No, those are all the comments for now.
All right, see, I'm conscious of the time. Just a couple of things on the horizon, so I won't spend too long on these. One is potential reform on restrictive covenants. So the government was consulting on that. Consultation closed on, in February. So it remains to be seen what, if anything, the government will do. In terms of the consultation, they were asking, should we just ban the use of restrictive covenants? Or should we only use them where the employer pays some form of compensation to place restrictions on the individual? So that is something that obviously is on the government's radar. The consultation has just recently closed, so we'll just have to wait and see what, if anything, comes on the back of that. And the other thing on the horizon, which you might want to start thinking about and planning for, is neonatal leave and pay. I don't know if anybody has seen that. So there is a suggestion that come 2023, potentially, then there may be new provision for 12 weeks paid leave for those parents who have premature babies that require specialist care in a neonatal unit, which is being put in place to avoid parents having to decide whether to return to work or care for their sick baby. So a suggestion that come 2023, we may have new provision for 12 weeks paid leave to cover those situations. But obviously that's a little way off. But given how quickly the past year has gone, yeah, I'm sure it will come around soon enough. So just something to have on your radar. That also is something on the government's radar. So that was all I had. It has been a quick hour, and I'm happy to take any questions. Like, I don't have to rush off. I know that you maybe want to go and enjoy the very last of the sunshine. I'm grateful to you for giving up a sunny evening to be here. But if anybody's got any final questions, I'm happy to take those.
Just to maybe give it a few, lots of thanks coming through.
Great. I'm going to stop sharing the screen actually so that I can see your lovely faces. Oh, thanks, Laura. Yeah, first comment. Yeah. No, thanks, folks, and thanks for the questions as well. It's great to get a bit of feedback too.
Yeah, so I mean, if nobody's got any questions, thank you very much, Jill, for your time and
Not at all. Pleasure.
Very informative and very useful information. So thank you very much. Just a reminder again to do the survey at the end. That's going to come through your emails. It will much be appreciated. So yeah, thank you very much, everyone. Thank you for joining us.